Patents protect inventions. So patents will protect the structure and function of something that is new and novel. So if you invent a new type of product, a consumer product that isn't on the market, that's going to be appropriate for a possible patent. Now, how that product operates might also be appropriate for a patent. So patents protect inventions. Copyrights, on the other hand, protect creative expressions that are reduced to a tangible medium. So for example, if you write and publish a poem, if you take a photograph, if you draw an illustration, then that is going to be properly protected with copyright. So again, copyrights protect creative expressions that are reduced to a tangible medium. Now, what are some of the big differences between patents and copyrights in terms of logistics and how you obtain them? In general, patents are going to be a lot more expensive to procure than copyrights. With patents, the process is also a lot longer because after you file your patent application, it's going to take several years, sometimes 1 to 3 years, for the patent office to even examine your patent application. Copyrights, on the other hand, tend to get examined within a few months, sometimes even as quick as a few weeks. So copyrights are going to be a lot quicker to obtain registration of. Now, another key distinction is that copyrights are filed with the Copyright Office, whereas patents are filed with the United States Patent and Trademark Office. So they're different branches, different government agencies that are actually handling the paperwork that you're submitting the paperwork to. So another big distinction is in price. Patents tend to be a lot more expensive to obtain, not just in legal fees, but also in government fees. Copyrights are a lot less. Typically, you could probably get a copyright for, even with counsel, typically less than $1,000 with fees, and that's probably on the high end. Patents, on the other hand, tend to cost several thousands in legal fees, and just the filing fees you're looking at for a small entity at $830. A micro entity is $455, and if you're a large company, you're looking at $1,720 just for the government filing fees. So as you can see already, patents tend to be a lot more expensive than copyrights. Now, another interesting thing about patents versus copyrights is the time that they last. So patents are going to last for a limited amount of time, 20 years from the priority date. So if you file a patent application today and it issues in 3 years, the life of the patent is going to be determined based on that filing date. Now, copyrights, on the other hand, are going to last as long as the author is alive, plus 70 years. And again, that law could be subject to change, but as you can see, it's going to last a lot longer than patents. So that's another really important thing to keep in mind, is the life of the actual intellectual property right. Patents and copyrights might both be appropriate for your business. And one common area where copyrights and patents are considerations are whenever you're developing software. So it's possible to protect software with a patent, but it's also possible to file a copyright registration on the underlying source codes. Now, one key tip for you guys that do software out there, the key thing to remember about copyrights is that whenever you're actually going to enforce your right, a patent might actually be a lot more powerful than a copyright, because it's possible for someone to reverse engineer your end product without actually duplicating or copying your code, which is essentially what a copyright protects. It's going to protect copycats. It's going to protect others who are going to take your materials and copy them outright. Now, with a patent, even if someone reverse engineered your product and developed their own version of it, it is possible that they could still be liable for patent infringement, depending on the types of patent claims that you're able to get issued. Now, again, if you have the resources, though, it's always a good idea to consider filing both patents and copyrights, and you should also consider even filing trademarks, but that's the subject of another video. Another thing to keep in mind is the remedies available. So if someone copies your invention and you have a patent that has claims that read on that invention, then it is possible for you to have a patent infringement suit available to you. So you could send the infringer a cease and desist letter requesting that they stop copying, stop practicing your invention without authorization, so you could try to obtain perhaps royalties, and if they don't comply, then you could possibly sue them in federal court. Now, with copyright, it's similar, but it's not a patent infringement suit. It would be a copyright infringement suit. So keep that in mind. There are different remedies that are going to be available to you. I hope you guys found this video helpful. Again, we covered the distinctions between patents and copyrights. Patents are going to protect the structure and function of your invention. Copyrights are going to protect creative expressions that are reduced to tangible mediums. I just want to remind everybody that I highly encourage you to seek professional counsel to help you as you navigate the IP world. It's a really good idea to retain counsel to advise your business directly, because the facts specific to your business might actually require you to do one or do another or do both. I hope you guys found this video helpful, and please subscribe to our channel, and if you have specific topics that you want covered, please feel free to reach out. Thank you so much for watching.